Yeah, so I hope that we have your consent. Okay. Yeah, let me first introduce the Khidki Collective. Khidki Collective was formed in 2021 with the idea of building a conversation between academics and the public, because a lot of time we see that academic knowledge is within the very limited sphere, and it's highly jargon oriented. It's also not accessible. So our prime interest was to make it accessible, to get academics talk to public again. And we've also, the group of people who came together were all thinking about Deccan. We were all working on the Deccan, so we've been largely focused on the Deccan. However, it's not a boundary that is set. We have done a few. We've experimented with a few things over these years. One series which is ongoing is the Deccan Conversations, where we invite scholars working on the Deccan to present to public. These are online talks. Whenever we find new work happening about the region, we invite people to present to us. To public, and our primary interest again is that they should be accessible. They should make it simple and understandable to common public. The second thing which we have done is we do these series writings, which is we usually invite about eight people working on a topic together to respond to a question, and we publish it in popular media like the News Minute or the Wire. We've done three sets of series. One was on the Police Action 1948, which was also translated into other languages. And we are very keen on working on the languages of the Deccan. That is, so we had it translated into Kannada, Marathi, and Telugu. Again, the work of translation depends on whether we find volunteers to do it. And this is a completely voluntary based collective. So we try to do it pro bono, whatever we are able to get together. In this series, we are actually working on discussing the public history, various public history initiatives, thinking about the idea of public history itself. And for that, we have invited people who've been doing significant work in this sphere. Um, Today we have Srijan Sandip Mandal, and we are very thankful to him for agreeing to speak to us. I'm going to invite the speaker to present. I'll just present his introduction. Srijan Sandip Mandal is a historian, keen on researching and teaching legal history, the philosophy of history, and public history. He's currently assistant professor of history at NALSAR University of Law, Hyderabad. He's also the secretary of International Federation for Public History. Before joining NALSAR, he was on the faculty for the Center for Public History at Srishti Manipal Institute of Art, Design and Technology, Bangalore. He holds a PhD in history from the University of Hyderabad, where his doctoral thesis was awarded the university's annual medal for the best PhD thesis in the discipline. Over to you, Sandeep. Thank you, and welcome to Khidki.
Thank you, Yamini, for the warm introduction, and thank you, Swati, for inviting me to be part of this Past Matters talk series. I hope I'm able to contribute meaningfully to it. So, as you can see on my screen, which I hope is also your screen, the title of my talk today is Judicializing the Past, the Rise of Juridical History in India. So, I'll come to this in a bit, but let's begin with firstly, what is public history? Now, the word public history is used in various ways by various people in various different contexts and domains. But public history is a recognized discipline, sometimes described as a movement with journals, with associations, with the usual paraphernalia of academia. And according to that discipline, which is known as public history, which emerged in the United States in the early 1970s, late 1970s, I would say, public history can broadly be defined in these two ways. One, as you can see, is from the National Council on Public History, which is the largest organization of public historians in the world. It's headquartered in California in the United States, and it mostly has American members. They describe public history as the many and diverse ways in which history is put to work in the world. Therefore, history that is applied to real world issues. Another definition that I've put here is by Robert Kelly, who is one of the earliest people to have written on what public history is or ought to be. And this was published in the very first issue of the journal, The Public Historian, which is a journal published by the National Council on Public History and is usually regarded as the preeminent journal in the field. His definition was pretty simple. Public history refers to the employment of historians and historical method outside of academia. Despite the fact that such definitions exist, the general consensus among those who identify as public historians and those who consciously purport to practice public history, whether in the academia or outside, tend to hesitate when it comes to defining the concept or the discipline. As NCPH itself puts it, public history is basically, you know it when you see it. So it is a tricky thing to define. So mostly what they focus on is the practice of public history. Yet I'm beginning with the definition because it's helpful to understand what is it that I'm speaking of when I'm speaking of juridical history in the context of this discipline called public history. So now that I've hopefully been able to clarify what public history means, at least in the context of this talk, let's move on to what is juridical history. As far as I know, this term is not widely used or used at all. So I suppose I can take the credit of coining it, but I might be mistaken. So to me, at least, juridical history is a term that can be used to describe the interpretation of the past offered by the judiciary in the judgments that they issue to adjudicate the cases before them. This is a very long-winded way of saying that there are many occasions on which courts of law find themselves adjudicating disputes that pertain to the past, where the interpretation of the past has a bearing on the judgment or has a bearing on the decision that the court will issue. So to that extent, judges find themselves in the awkward position of playing historian. They do what we do in the discipline of history, that is to identify primary sources, try to interpret primary sources, based on that interpretation of primary sources, find in favor of one party or another. The last bit is not something that historians do, but judges, by the very nature of their work, are required to do it. They are required to find in favor of one or the other party. However, this genre of history writing, and it is a genre of history writing because here is an institution of people that are writing history, is not something that's recognized by historians within the academia or even outside it. Whether it's the discipline of public history or the discipline of academic history, juridical history, or histories produced by judges in judgments that they issue is not something that is recognized. So then the question is, how does it become public history? Is it even public history? So let's go back to this definition. So I'm arguing that juridical history is an unrecognized genre within public history because it is a history that is applied to real world issues. Whenever a case is brought in front of judges, they are trying to solve an actual issue that they have to adjudicate based on evidence that is presented to them. So to that extent, juridical history can be considered public history. Similarly, if we look at the other definition that I presented to you, which is public history refers to the employment of historians and the historical method outside of academia, here you have the historical method as understood by judges and as applied by judges being done in a court of law, and the result of that is public history. So therefore, when it comes to the definitions acquired by, say, offered by both the National Council on Public History and Robert Kelly, we can safely say that juridical history is an example of public history. It is a genre of public history. Now, I want to demonstrate how this genre works by looking at what I consider, and what I think by consensus most would consider, the preeminent example of this genre of public history, which is the so-called Ayodhya judgment. I'm describing it as the preeminent, not just because of the media coverage and the public conversation around it, but also because of the impact that it has had. In the wake of the Supreme Court's judgment on the Ayodhya issue or the Ram Janmabhoomi Babri Masjid dispute, you have had a number of court cases around other disputed sites, primarily in Varanasi and Mathura, as well as some other sites in North India that have also gone to court. Similar issues. A Islamic structure being described as having taken the place of an earlier Hindu structure through the act of destruction, and therefore a plea for justice, which would allow for the restoration of the original historic structure, the original Hindu structure, at the cost of the present-day Muslim structure, Islamic structure. So that's broadly the kind of genre of cases that are now appearing before courts, and most of them follow the same template that was set by the Ayodhya judgment. So not only is the Ayodhya judgment issued by the Supreme Court at the pinnacle of a very long dispute that began in the mid-19th century, it also inaugurates an era where you have petitioners going to the courts of law to seek justice or redressal or adjudication in favor of their claims that has something to do with history. So that's why I think it's important for us to look at what this preeminent example of juridical history did with history. How did it approach history? So let's begin with how the judges in the Supreme Court thought about history in this judgment. A brief background here before I begin with this, and this is where, so this is the site of the Babri Masjid. The masjid, as you well know, does not now exist. It has not existed since the 6th of December, 1992. These three domed structures is the masjid itself. And this whole site is known as the inner courtyard. This is a wall that was built in 1857, 1858, after the British had conquered Awadh. And this is known as the outer courtyard. This is the Ram Chabutra, which we will come back to. So remember this is the inner courtyard where the mosque is. This is the outer courtyard where other structures are, which have more to do with Hindu worship and where Hindus have continuously worshipped since about 1857, 1858. And within this inner courtyard, Muslims have continuously worshipped since about 1857, 1858. So on that, there was agreement that from 1857, 1858, or maybe just before then, both Hindus and Muslims have been worshipping at this site. Nevertheless, the claim of the Hindu side, and I'm calling it the Hindu side not because I'm trying to reduce them to their religious identity, because that's how the Supreme Court refers to them. Although there are a number of litigants there, the Supreme Court effectively refers to them as the Hindu side. The Hindu side, basically, what they were trying to do was to claim that beneath this Babri Masjid was a Hindu temple dedicated to the worship of Ram. And therefore, this site must be restored to them so that they can build a temple in honor of Ram and restore a temple that apparently existed historically. So that was the central claim of this dispute, that there exists a mosque, or at least existed till 1992. The Hindu side claimed that the mosque was built on a Hindu temple, and therefore they wanted the land so that they could build the temple. Now, most of the cases that the Supreme Court of India dealt with in December of 2019, while issuing what we now know as the Ayodhya judgment, predates the destruction of the Babri Masjid on December 6, 1992. Which means that when the claims were made before the court first, these claims were made while the Babri Masjid was extant and standing. So that's the background. Now let's come to how the Supreme Court went about arriving at the judgment that they did, which unanimously gave control of this land, both the inner courtyard and the outer courtyard, to the Hindu side, specifically to a litigant called Ram Lalla Virajman. Ram Lalla Virajman is interesting because that's not an actual person. That's what's known as a juristic person. That is a person for the purposes of law, but that is actually a deity. So the litigant who won this case was a deity, Ram Lalla Virajman, small statues of whom were installed inside the mosque in December of 1949. Just think about that. This case was won by a deity. So that's like one of the so much. So how are the Supreme Court judges and that is a more enhanced bench than other benches of the Supreme Court, whose judgments can be overturned.
Sandeep, you're getting stuck.
Yes, sorry.
There is probably
Okay.
some issue of internet because we couldn't hear. You started talking about the deity, and after that, it got stuck.
Okay. Okay. So are you able to hear me now?
Yes, I can hear you now. Yes.
Okay. Let me just change the Wi-Fi. Sometimes there's a Wi-Fi connection issue that needs to happen on campus.
Yeah.
Able to hear me, Yamini?
Yes. Yes, we
Yeah.
can hear you.
So, okay. Now, so just as I was saying, this case was won by a deity, Ram Lalla Virajman. So how is it that the 5-judge bench of the Supreme Court arrived at this judgment? And it's a 5-judge bench, and that's significant because the 5-judge bench is known as the Constitution Bench, which means that is in the types of benches that one can have, it's the largest bench possible. It is possible to have far more judges than 5 on a bench, but in terms of types of benches, the Constitution Bench is the
Sandeep, you're stuck again. Sorry, Srijan, you're stuck again. Yeah. Uh, you're getting stuck again, actually.
You were stuck, Srijan.
Okay, sorry. Then maybe I should switch off my video and maybe that will help.
Okay. Yeah, you can try that.
Yeah. Is that helpful?
I mean, right now we can hear you. I'll tell you again if we can't.
Yes. So as soon as you're unable to hear me, just let me know.
Yes, sure. Okay.
So what's happening is that these 5 judges are acknowledging some of the issues with dealing with a historical claim. As they say here, they say that we must exercise caution and to ensure that an absence of evidence is not treated as an evidence of absence. So the specific sentence is one must exercise caution before embarking on the inclination of a legally trained mind to draw negative inferences from the silences of history. Which means basically what they're saying is that the absence of evidence, just because there is not evidence of something, does not mean that that something did not happen. And they acknowledge that this is.
You're stuck. Can you hear us, Srijan?
So the decision. So they acknowledge that absence of evidence is not evidence of absence. They acknowledge that one must be very careful to use your legal training when you are working with historical material. Despite that, they begin by saying that there is a report that was prepared by 4 historians, R.S. Sharma, M. Athar Ali, D.N. Jha, and Suraj Bhan. This report was prepared for the Allahabad High Court, which was first handling this case before the case went to the Supreme Court. Now, in this historian's report, the idea was to refute the claim that there was a temple below the masjid, and therefore this site was the site of the worship of Ram. This was the site where Ram was born, and therefore this site must be returned to the Hindus. This was a report that was framed many, many years ago. And what the Supreme Court does is that it says that this report is irrelevant. It has no evidentiary value. So the first thing that they're doing in terms of their reasoning to arrive at the judgment that they have is that they are saying that the work of historians who have tried to intervene in this case has no evidentiary value, and they want to ignore it. Why are they ignoring it? Because they are saying that when this report was prepared, the historians did not have access to the archaeological evidence that they were critiquing. And since this report, the Allahabad High Court had in the year 2003 ordered the Archaeological Survey of India to conduct a fresh excavation of the site, which revealed a lot of evidence that is something that the Supreme Court will deal with. Therefore, the historian's evidence or the historian's expert opinions is irrelevant in the face of archaeological evidence that has superseded it. So that's how they, off the bat, they have decided that the historians have nothing to contribute to a case that has to do with a historical claim, because the archaeologists have come in, and archaeology is a science, history is not. Okay? So the first thing that in some ways this particular preeminent example is doing is it's delegitimizing the work and the research and the interpretation of historians and privileging that of the archaeologists, because archaeological evidence and interpretation is thought to be more scientific and more rigorous. But then when they move on, and this is 207 pages later, and of course they are also dealing with it before, they are also saying that the Archaeological Survey of India's evidence cannot be used to this particular case. As you can see in the parts that I've highlighted in red, a finding of title here refers to whom does this piece of land belong, cannot be based in law on the archaeological findings which have been arrived at by ASI. Why can't it be done? Since you've already ignored the work of historians and privileged the work of archaeologists, now you're saying that even the archaeologists' evidence cannot be used to decide this case. Why not? Because of two reasons. One is that they acknowledge firstly that there appears to be enough evidence to suggest that something akin to a Hindu temple may have existed below the site of the Babri Masjid in about the 12th century. So in some ways, they are lending some credence to the claim that was made by the Hindu side that there is a temple beneath it and the temple belongs to Ram. But their problem is, in terms of dealing with the case, is that the temple that the Archaeological Survey of India's report posits, and it's a very controversial report, dates back only to the 12th century, whereas the Babri Masjid was built apparently by Babur in the 16th century. So there is a 4th century gap that cannot be explained by any available archaeological evidence, and for which there is no plausible archaeological interpretation available. That's the first problem. The second problem is that there is no evidence also to suggest that the mosque was built after having destroyed the temple that existed before it by 4 centuries. So they have no evidence of a temple existing on the eve of the Babri Masjid being built, despite the Archaeological Survey of India trying a lot of different things. And they have no evidence of the destruction of this temple for building of the mosque. They also do not have any evidence in the Archaeological Survey of India's report to suggest that the temple underneath was a temple dedicated to the worship of Ram. So they don't even have an evidence of that. And all they are saying is that from the Archaeological Survey of India's report, it appears that there is some evidence to suggest that there was a structure beneath it, and this structure appears to be Hindu, which means that the ASI's report is also not enough. So the two disciplinary experts whose evidence and inferences and interpretations should ideally allow you to adjudicate a case that pertains to a historical claim are inadequate and have been declared inadequate by the judges, by the Supreme Court, and by the Constitution bench of a Supreme Court, no less. So then, how do you determine the case? This is where, remember when I had showed you that map, I had told you that on one thing, all parties were agreed, that there was irrefutable evidence that both the Hindus and the Muslims worshipped at the site of the Babri Masjid from about 1857, 1858. On this point, there was some dispute about whether or not the Hindus were able to access the actual mosque, which was in the inner courtyard, remember the wall? But there was no dispute that they controlled and worshipped in the outer courtyard, because that was exclusively for them. There was no interest that the Muslim side had in offering namaz there or doing anything there. So the Hindus had a monopoly over the outer courtyard. And in the inner courtyard, they sought to worship whenever they could, which was the contention, which was a very contentious issue. So there is, as far as the judges are concerned, we know that from 1857, 1858, there is evidence of worship. So now look at what's happening. We are moving from the original claim, which was the litigant's claim, which was a claim about architecture, that there existed a temple beneath the mosque. Temple was destroyed, mosque was built in its place. Therefore, we want justice. Justice involves getting rid of the mosque, or at least giving us back the land, so that we can rebuild the temple which was desecrated or destroyed. Now, from there, in terms of actually dealing with these claims, the judges have moved on to worship and the history of worship. Property law, one of the ways that you can define or adjudicate disputes of property is to look at possession or usage. A property belongs to someone if they can demonstrate continuous usage or possession of that property. And another side might lose their claim over property if they cannot demonstrate continuous and uninterrupted usage or possession. That is why the judges have come to this question of worship. And let's look at the history of worship. Who is worshipping at this site, and for how long have they been worshipping? Because worshipping here is equal to or tantamount to possession or using. And therefore, through the history of worship at this site, we can arrive at the party to whom the title belongs, or the side to whom the title belongs, the Hindu side or the Muslim side. So what they point out is that there are 18th century travelogues, and these travelogues are presented by the Hindu side, and the Supreme Court relies upon them as the almost clinching evidence to determine to which side this side belongs. They say that there are 18th century travelogues that demonstrate the existence of the faith and belief of Hindus. So there is historical evidence in the form of travelogues which demonstrate faith and belief that this site was the birthplace of Ram. And there are some of these identifiable sites that are still existing, such as Sita Rasoi. And that there is a site which is known as Bedi, which appears to have been a square made of stone of about 5 inches in height, which was believed to have been the literal site where Ram was born, and which was worshipped, according to these travelers, even in the 18th century. And therefore, and which is why I've highlighted this part in red, that the historical presence of worshippers and the existence of worship at the disputed site, even prior to the annexation of Awadh by the British and the construction of a brick wall in 1857, is demonstrated by the existence of these two travelogues. One is by Tiefenthaler and the other is by Robert Montgomery Martin. Joseph Tiefenthaler and Robert Montgomery Martin. So, remember what the judges first did. They ignored historians' report which presented historical evidence saying that your, and we now have archaeological evidence, therefore that is more credible, so we don't need your evidence in your report. Then they have gone on to say that the archaeological evidence is inadequate, and they've come back to the historical evidence, which is the evidence of travelogues themselves. But at this time also, because they've already ignored the historian's report and the historian's evidence, they have not returned to that evidence. The historian's report is still being ignored, but the judges are now arrogating to themselves the job of the historian. They have now gone into the territory of looking at actual primary sources, such as 18th century travelogues in translation, to be able to arrive at a history of worship, which allows them to adjudicate the dispute. Because also remember, till 1857, we have evidence of worship from both sides. Now, beyond 1857, can we find evidence of worship? And through these two travelogues, they feel that they have found evidence of worship, but evidence of only Hindu worship. As the Supreme Court points out, the 5-judge bench of the Supreme Court points out that the Muslim side, which was represented by the Sunni Waqf board, could not and did not present any evidence to demonstrate the offering of namaz before 1857, 1858 at the Babri Masjid. The masjid existed, that is not under dispute. But the existence of the structure has, as far as the Supreme Court is concerned, very little value in terms of determining to whom the title belongs. For them, the question now is who has had uninterrupted usage and therefore possession of the site. And for them, usage and possession can be found by looking at records of worship. So worship becomes the important criteria. And they have found, thanks to the Hindu side submission, 2 travelogues. They found a number of others, but primarily they are relying on 2. But if you actually go through the remainder of the judgment and look at what in these travelogues they are using to base their claim that the Hindu side's record of uninterrupted worship is much longer than that of the Muslim side, you discover that they are actually depending on only one travelogue, which is that of Joseph Tiefenthaler's. This was a travelogue that was written in the mid-18th century, somewhere around the 1740s. This was a travelogue written by a Jesuit missionary. The Hindu side, representing among others Ram Lalla Virajman's clinching piece of evidence as far as the Supreme Court is concerned, is a travelogue written in Latin by a Jesuit missionary, not by a Hindu. There is no indigenous sources. This is a Jesuit missionary's 18th century, mid-18th century travelogue that has been translated into French, then being translated into English, then being published in the Proceedings of the Indian History Congress. And that article is what is cited in the Supreme Court judgment. Not even the travelogue in its original. The travelogue's French translation and edition, its English translation, that published in the Proceedings of the Indian History Congress, which is then cited by the Supreme Court. And according to that version of the travelogue, what you have is what I just said. There's a square box, which according to the Hindus of the 18th century is a cradle representing the birth of Ram. There is also an example of a house that Hindu worshippers believe to be at that site. And what they do is that they circumambulate or go around that site thrice, and then they prostrate on the floor in worship. And every year, when the birth of Ram is celebrated, they come to this site again in large numbers. How does Tiefenthaler know this? We don't know that. The traveler, Joseph Tiefenthaler, does not reveal the sources of his own information. So we don't know what sources he is following. We also don't, and from the travelogue and the portions of the travelogue that the Supreme Court quotes, we can fairly say that what he has written and what the Supreme Court is able to infer from Tiefenthaler's travelogue is not based on an eyewitness account. These 2 forms of worship, the one which is about going to what is considered the cradle of Ram and prostrating before it, and then coming every year in large numbers on the birthday or the birth anniversary of Ram, these are 2 forms of worship that Tiefenthaler has not witnessed by his own eyes, with his own eyes. This is what he has been told and he has heard as happening in the site. So this is not considered what would be called hearsay evidence. And the Supreme Court acknowledges that travelogues are very problematic documents because of the nature of trying to distinguish between what is hearsay and what you've actually witnessed, what you have seen, what you have observed. Nevertheless, in the absence of any other evidence, because there is no evidence of the Muslim side offering namaz, and there is only this evidence, effectively one travelogue, in which the traveler, based on accounts that he has heard from others, and we don't know who these others are, is claiming that this particular site has two kinds of worship happening, which they mention. The travelogue does not mention that the Muslims of that time, which is the 17th, 18th century, were offering namaz in that mosque. Now, the Supreme Court could have, but does not, for instance, ask the question that the very existence of a mosque and the fact that Muslims, people are offering namaz in a mosque is not extraordinary. It's not unique. It's not different. If you are a traveler traveling through a land, what is it that you are likely to record? Everyday practice or something that is exceptional and unique? One might venture to guess, and again, this is also guess because we are all in the realm of speculation at the moment. One might venture to guess that something like this, where a box-like structure is considered so sacred that people are coming and prostrating before it, and people are gathering there every year and worshipping it, is interesting and unique, especially for a Western audience, as opposed to an existing mosque where people are offering prayer on Fridays or maybe multiple times a day, which is what you would expect to happen in a mosque. But this is not something that the Supreme Court goes into, because this is the only piece of evidence they have found of worship that goes beyond 1857, 1858, where both sides are, both Hindus and Muslims are worshipping at the site. So therefore, because they have found this one travelogue, basically one travelogue, they cite multiple other travelogues and they cite gazetteers as well. But in terms of credible evidence, what they really depend on is this one travelogue. They say that what this does is that this shows that despite the existence of an Islamic structure, the Hindus felt the site to be so sacrosanct to them that they kept worshipping at it, even though the site had been turned into a mosque in the early 16th century. 1520s is when the Babri Masjid was said to have been built. So what the inference that the Supreme Court is drawing is that we are looking at possession. We are looking at use. In terms of use in the form of worship, which for them equates to possession, the Hindus seem to be so committed in their faith and belief that this site is the site of the birth of Ram. This site is the site where his palace was. This is the site of an earlier Ram temple, that they kept coming to worship at it, even though the mosque existed. But on the other hand, they say, and which is the last sentence, that the Sunni Central Waqf Board has not been able to offer any evidence of namaz being offered before 1856-57. Again, the fact that the mosque exists does not, for the Supreme Court, automatically imply that there was namaz being offered there. They want evidence of namaz being offered there. So what are they doing? They are doing what they want themselves, that is one of the pitfalls of using a legal mind to historical material, which is to treat the evidence of absence or the absence of evidence as the evidence of absence. Because there is no travelogue or no document before the 1850s to demonstrate that even in the 18th and the 17th century, the mosque was actually used to do what mosques are usually supposed to be used to be doing, which is to offer namaz. Because there is no document that definitively says that, we must assume that namaz was not offered there. Only the Hindus were accessing and using the site. Therefore, the Hindus have now presented convincing evidence or clinching evidence in the Supreme Court's reasoning that shows that their claim or possession over this disputed structure is longer than that of Muslims. Not necessarily dating back to the 1520s when the Babri Masjid was built, but at least it is longer by about 100 years than the evidence that the Muslim side is able to present. And because this is a civil case, the standard of evidence is preponderance of probabilities. It is more probable that the Hindus have more continuously and in an uninterrupted manner worshipped at this site than Muslims. Historical evidence, not archaeological evidence, historical evidence to say that Muslims worshipped at this site before 1857. So let's now come back to that historian's report that they ignored. What were some of the conclusions of that report? And could the Supreme Court have drawn on any of that report? So what they say is that there is no evidence in textual evidence, just of the kind that the Supreme Court is using, to suggest that before 18th century there was any veneration of Ram himself, or that there was a site attached to his birth. There is no evidence of that. And this legend that the Babri Masjid occupied does not arise until the late 18th century. And they say that the full-blown legend of the destruction happens only in the 19th century. So in some ways, some of the findings, not all of the findings, some of the findings of this report are consistent with the kind of evidence that the Supreme Court is drawing on. And basically, the Supreme Court has also found a travelogue that dates to the 18th century or the middle of the 18th century that speaks about this site being associated with Ram. They have not found anything else before it that talks of it. So which is what one of the things that is used in the historian's report is that they point out that the Ramcharitmanas, which is the most popular version of the Ramayana, when we read or recite the Ramayana today, what we are doing is we are reciting the Ramcharitmanas more than the Valmiki Ramayana. Ramcharitmanas, which was composed in the 17th century, makes no mention of the Babri Masjid. That the fact that there is this mosque which was built on a temple which is supposed to have been the birth of Ram, it makes no mention of that. And it is the most influential text dedicated to the worship of Ram emerging from North India. It makes no worship of that. The Skanda Puran, which is another text which looks at and has something called the Ayodhya Mahatmya, the historians point out, do not make any mention of Ayodhya and this particular city called Ayodhya, and they make no mention of that. So there is enough credible evidence of the historical variety, of the same variety that the Supreme Court is using, that the historians also used to come at the conclusion that the Hindu side's claim is not sustainable. But remember what the Supreme Court did. They ignored it at the very outset, saying that we have archaeological evidence to demonstrate otherwise, so we will rely on that. But when the archaeological evidence came, they said that that's also inadequate. So they went back to historical evidence. And what did they find? They found that one travelogue says that there is evidence of worship and traditions of worship, and therefore there is greater evidence of the Hindus worshipping at the site than Muslims, despite the existence of a structure. That existence doesn't matter. So therefore, what do they conclude? The judges conclude that the title of the disputed site therefore belongs to the Hindu side. And it belongs to the Hindu side because on the balance of probabilities, you can show that they have uninterrupted possession demonstrated through worship of this site dating back to at least the 18th century. On the other hand, the Muslims have evidence to only show that they were offering namaz there dating back to the mid-19th century and nothing beyond that. Again, the very existence of the mosque is not enough evidence of the namaz being offered. So physical evidence, architectural evidence in the form of a mosque is not enough, but documentary evidence in the form of a single travelogue is enough. So effectively, what has this then almost emblematic example of juridical history done? It has firstly delegitimized the work of the historians. It has secondly arrogated to itself the work and the expertise of the historians by looking at primary sources and analyzing and interpreting primary sources allocating it evidentiary value for themselves, and they have, based on that, come to a conclusion about a very controversial title dispute that goes back 100 years. And because it is a Supreme Court judgment, because it is a judgment of a constitution bench of the Supreme Court, which is the most authoritative bench that the Supreme Court can constitute, this judgment also is precedent that can be used by other judges in other courts, whether the Supreme Court or the High Courts, to come at conclusions about disputed claims made about the past without actually having to engage with historical scholarship, historical research, and historiography, which is what the Supreme Court themselves acknowledge in this very judgment that judges must do. And they must be wary of using their legally trained mind on historical material. So that is what constitutes, in my eyes, the perils of juridical history, as well as the power of juridical history. And where does this power come from? The power comes from the fact that these are judges adjudicating disputes, actual disputes in a court of law. Whatever judgment they give has actual consequences. As you saw with this, as soon as the judgment came, within 5 years, the full Ram temple was built, it was consecrated, everything was done. So this is not an academic debate. Their findings about the past, however tenuous the evidence that they're basing it on, has actual concrete real life consequences on real issues. And they are doing it while they're ignoring historians than the work of historians. So that is the danger and the power of juridical history. And the thing that they can do is that they can legitimize claims that were made in the public sphere, as it were, or in the world outside, in a way that nobody else can. Right? There has, of course, been this claim that this site was built on the Ram temple for decades. But it's only when the Supreme Court issues its judgment does it legitimize this popular belief that, yes, indeed, the Babri Masjid was built on a desecrated site of the Ram temple, and it was built on the birthplace of Ram. Now, the thing is, you might say that, but just as I presented, that is not the conclusion that they come to. They don't say that there is a Ram temple beneath it. They are not saying that this is the birthplace of Ram. But also think about it this way. Unlike other genres of public history, which people actually read or watch or listen to or engage with, very few people outside the legal fraternity are going to read a 1,045-page judgment, which means for the public at large, what is it that's being reported? That the Hindu side has won. What was the claim of the Hindu side? That this is the site of the birth of Ram, this is the site of a Ram temple on which was built a mosque after the desecration and destruction of the Ram temple. Therefore, justice demands that we get the land back and rebuild the Ram temple. No one is actually looking at the reasoning offered here, or at least very few people are. So in the public perception, it's a confirmation of the popular claim that had been made for decades, certainly since the 1980s, late 1980s, that this mosque is on the site of the birthplace of Ram and a temple dedicated to him. So you can see what can happen with other cases and other disputes, specifically the ones in Varanasi around the Gyanvapi mosque and the one in Mathura around the Shahi Eidgah mosque, where popular claims about the past they can be legitimized in a way that no other history can be legitimized. Therefore, I want to argue and want to submit that historians and public historians, those who engage with public history, must engage very seriously with this genre that I'm calling juridical history, that is on the ascendant now. There have been earlier examples of juridical history as well. But after the 2019 judgment, there appears to be a greater incidence of disputes about the past being taken to court. So how do we approach it? Again, we are not political parties, we are not activists. Most of us are either students and teachers of history or lay individuals interested in history. So the least we can do is study the genre, this is a genre of historical writing. It may be completely covered with legalese, but it is a genre of historical writing. Study it, understand what is the method that's being used. How are the claims being substantiated? Do those substantiated claims make sense? Does the corroboration make sense? Is there credible evidence being brought to? Then critique this genre. And if you are a teacher, then teach it in class. When we look at examples of history writing, if there are courses being offered on public history, can examples of juridical history be part of such courses, so that students also recognize how history is being conducted in courts of law, constructed in courts of law, and the real life consequences of those constructions, however flawed they might be. And finally, and this is what the historian's report tried to do but failed to do, was to actually inform future judicial interventions into the past by trying to show them the kind of evidence that they could rely on and how they can arrive at more historically sound interpretations of the past rather than ones that can be very dangerously tenuous. And with that, I'll end my presentation. If you have any questions or clarifications or comments, please feel free to ask. Thank you.
Thanks, Srijan. Just going to invite my colleague Himabindu to offer a summary and to do the moderation.
Thank you, Srijan. I think this is something that is like really opened up a lot of conversations that we've been having on public history, and more so the importance of the consequences that a genre like judicial history has, considering to quote you, the kind of power that it holds and what it is capable, what such a history is actually capable of doing to to the larger public sphere. So to kind of map the talk and bring it together, so we started, Dr. Srijan started with elaborating on what is the definition of public history, how do historians perceive public history largely, and then moved on to talking about the main question for the talk, which is does judicial history, which has a larger consequences to public life in general, become public history itself? That was a question that that he has worked through the conversation by bringing into discussion the most recent judgment of the Babri Masjid Ayodhya judgment, and to bring in how the judiciary conceives public history, to see how and evaluate how judiciary understands sources, understands history itself, and what kind of sources are privileged and what kind of narratives are privileged over certain others, where he brings in the conversation about the historian's report, which is based out of architectural and textual evidence. And the Supreme Court constitutional bench rejects this historian's understanding of the whole issue and the evidences that they bring to fore, and how the Supreme Court undervalues something which is textual and architectural, and privileges something which is more archaeological. And by archaeological, they draw on the same sources and use one source which kind of shows the nature of continuous worship, as opposed to the existence of a physical structure or an architectural structure itself, and privilege textual sources over the existence of physical material sources of architecture itself. So historians' evidence is considered as inconclusive and not enough to support the claim, and then archaeological claims are given more credibility. And even then, even when archaeological claims are not considered as holding much value, then you come back to the historical evidence that is provided and actually create a different kind of a claim, not something that historians have provided in their report, but instead of looking at it, it is almost like placing. It is not about the land or propriety of the land anymore, but it becomes it brings in the idea of everyday continuous worship or practice of worship, and privileges worship over evidence of physical existence of the place. So this kind of brings into question how sources are conceived at large to arrive at judgments, how are and how judiciary kind of values its sources and creates a different kind of creates a narrative which is which supports a more popular belief as opposed to creating as opposed to evidence-based narrative. It kind of creates a narrative which is to support the larger existing public opinion or the dominant popular belief. And this brings into the question what he ended the talk with on the power of judicial history itself and the necessity, all the more, and in this contemporary moment, to engage with history and to bring into and all of us need to be informed about this genre and access it, critique it, and engage with it so that we know what we understand or unpack the power of judicial history as a genre itself. Thank you, Dr. Srijan. And it was important for me, like my primary area of interest is also media history. And most times we engage with communities which do not hold a history of textual evidence, for example. So that kind of excites me as well. So we'll open up the floor for discussion and see if we have any questions.
Hi, Srijan. Srijan, hi. Srijan, are you able to listen to me?
Yes, please ask your question.
Yeah, it was wonderful, Srijan. Yeah.
Yes, yes, Dr. Vakish.
Yeah. See, is there, because is it judiciary's way of looking at history? Can we say it so? Or judicial history? Because I think this is somewhat a kind of, can we take it? Is it a case of convenience, taking some sort of convenient evidence for a preconceived idea? Can we take it in that way? And I have some problem with the nomenclature. Not the judicial history, but how judiciary is looking at historical evidence, keeping the circumstances of politics at a given point. How should we, the nomenclature part, and then the dangerous points you have already kept clearly. That's very clear. But then, was the judiciary taking a very a kind of an evidence which suits its purpose, then going objectively with it?
Should I answer now, or should we do one by one, or how do you want?
You can answer this question now.
Okay. So I think there was some problem with my internet. So Dr. Vagishan, what I heard was, first, the question you asked was that, is this just convenience rather than actual judicial method? And I'm tempted to say yes, because let's look at the context. And this is something that I didn't cover because I was more focused on the genre. Is that the day-to-day hearings on this case started a few months after the Bharatiya Janata Party, which rose in prominence in the late 1980s on the back of the Ram Janmabhoomi movement in about August of 2019. The judgment finally comes in anonymous, remember, unanimous also, in December of 2019, which is 6 months after the Bharatiya Janata Party has come back to power with an increased majority, where they have 303 seats on their own, and they don't need any allies anymore. And their vote share has also increased to 36%. In such a scenario, if the Supreme Court had found anything other than what they did, what would be left of their legitimacy, given that the popular mandate rests with a political party that definitively believes that the Hindu side should win? So to that extent, one can say that yes, indeed, it was a convenient judgment. They already knew what the answer would be, and they just needed an evidentiary and a methodological basis to arrive at the answer. So to that extent, yes. Nevertheless, they have still devised a method, and they have still looked at some evidence and not others. And because Supreme Court judgments, as all judgments, but especially Supreme Court judgments of the Constitution bench, tends to have precedential value. It can become precedent, just as it is becoming precedent. And similarly, other judges, when found in such politically sensitive circumstances, will draw upon the same flawed methodology, as I would argue, to arrive at similarly convenient judgments which have very real political, socioeconomic consequences. So to that extent, even if we recognize the convenient context, we must still call out the method and the sources and try to engage with it also by giving them the benefit of the doubt and saying that you're playing this game, so let me also assess you on the game that you're playing and critique you on the game that you're playing. You also had a question about nomenclature, and you were unhappy with the nomenclature. I didn't quite get that. Hima, did you get the question about the nomenclature? I'm not sure.
His voice was unclear actually for all of us.
Oh.
Yeah.
Okay, so Dr. Vagishan, if you come back, I can address that question as well. Otherwise, we are anyways meeting day after tomorrow at work, so we'll carry this discussion forward there.
There are some questions in the chat box, Srijan.
Yeah.
Chantu had asked.
Question, right?
Yeah.
Yes.
It's related to print and.
I would say, Chantu, it does relate. See, no judge will admit that, at least maybe this is making a tall claim, probably potentially contemptuous claim, but usually judges are unlikely to admit that their judgments have anything to do with media reportage. They are unlikely to admit that because they have to still find another a reasoned way of arriving at what they may have learned from media itself. So there is probably a meaningful connection between what is available in the media and what is being basically bombarded upon us and judgments that come out of it. So there is a connection there. The problem is it's very difficult to reliably make that connection if you're engaging in a scholarly end. As an everyday conversation, yes, we can say that there is a causal relationship between what the media is saying and what the judges are saying. But because their judgments are unlikely to acknowledge that, we can at best create a context which suggests that there might have been some influence of the media. But unfortunately, because of the reasoned nature of judgments, we also have to take those judgments at face value and engage with them, which is what I would say that I'm trying to do. And in terms of how they become public history, so they are almost, I would say they're a unique genre of public history in the sense that they are not interested in the public. They have no desire to communicate to the public because the judgments are not meant to be understood by the public because of the technical nature of it and because of there is no need for that judgment to be 1045 pages. If you go through it, you're like, boss, just edit the damn thing. You could have done it, but they chose not to do it because there's also this judicial trend about just increasing the size of judgments by dump quoting everything. They do a lot of dump quotes. That's another problem of the genre of the judgments itself. So they didn't need to do this. So they don't have any obligation to communicate to the public, of being accessible to the public, nothing. But they are just empowered uniquely to change public lives by their opaque judgment. And there's nothing we can do. That's just the nature of the institution. And so therefore, trying to unpack all of it is also important. Like, for example, until I read the judgment, I had no clue that this is how they arrived at the judgment, because whatever reportage I read on the judgment, analysis I read on the judgment, none of them sort of put it in this way. And I was very surprised that this is the tenuous basis of coming to that conclusion. And I'm like, how does that work? So they are public historian, or they are doing public history only to the extent that they legitimate historical claims or claims about the past, and that they are powerful enough to change the lives of people, not because they actually are accessible or communicate effectively or are meaningful in any way.
Yeah, I think Pramod had a question. Pramod?
Yeah. Hi,
Sorry,
Srijan.
please.
I joined a bit
Hi.
later. Am I audible? Hello? Yeah.
Yes, of course.
Yes, you are
Please.
audible.
I
Yes,
joined
yes.
bit later, but thanks. It was a very fascinating talk. I had one question. I was just thinking about how I was reading some of the judgment regarding temple entry movements in around 1950s and 60s, and the evidence provided by the evidence provided for and a progressive judgment, what our constitution claims, and the conflict between history and morality that comes very round way in that those kinds of a judgment. I can give you, like, for example, Swaminarayan judgment in Bombay's temple entry movement, or so, where history become irrelevant. So my question is this only because, yes, I understand the importance of Babri judgment and its implication, but can we call it a certain way of an judicial history, or is it something what uh, as a judiciary is described as a pillar of a democracy? It's a executive, it's a fourth kind of a pillar. It functions where judiciary demands. Look at the ways in which UAPA laws are extended and all those things, you know. So my question is, can we say judicial judgments as a historical one? That one question is that way of a judicial history. The second is, how does one think about the role of an executive? Because you also mentioned it, you may have elaborated earlier. So we see in a progressive judgments also, the history is irrelevant for a judicial judgment. So yeah, thank you.
Thank you. So I suppose it depends on the, so for example, I'll be honest, I'm not familiar with the judgment about the temple that you're speaking of. But the easy thing, I would say, the easier thing about the temple entry or any claims about temple entry is that there are constitutional rights, fundamental rights that guarantee that there can be no discrimination in sites of public resort. That's the term that's used, I think, public resort. So you cannot deny anyone entry to a temple on the basis of caste, which is, for instance, the same thing happened in the Sabrimala judgment. In the Sabrimala judgment, what did Chandrachud, who wrote the majority opinion, what did he say? He said, history aside, and what you're saying, he ignored history because he said that there is a fundamental right to equality that women have, that no temple, no matter what tradition they invoke, can ignore. So there, what happened was that the Supreme Court was able to privilege fundamental rights, which are constitutional rights, over tradition. Here the problem is, and with most other cases that are coming, especially the two principal cases in Varanasi and Mathura, as well as in some other places, it's not about constitutional issue at all. It's an issue of property. Property is a civil law issue. Property does not have very many things to do with constitutional rights. So there, you don't have access to rights that you say supersede history. And because the claim is about the past, you are almost forced into adjudicating the past. It's not that the judges are at fault. The case was brought to them. They did not choose to have the case brought to them. The case was brought to them because a dispute could not be settled within the communities themselves, and they wanted a neutral arbiter. The judges became the neutral arbiter. Once they become the neutral arbiter, the problem is, how do they adjudicate it? And if it's a claim about the past, they have no other way of adjudicating than dealing with the past. Once they start dealing with the past, then the problem becomes that how do you deal with the past? And this is where they start parting ways from the historians, and they create their own version of the historical method, which suits them, because also they have a much difficult task than we do. Historians have the ability to say silence, we can't say, therefore let's move on. They can't. they have to find in favor of one or the other party. They have to do, which is why the pretentious term is preponderance of probabilities, which is the legal standard in civil cases. In criminal cases, it's beyond reasonable doubt. It's because they have to come at a judgment. They have no other choice. So in the preponderance of probabilities business, you have to find for one or the other. So you will overextend what historical evidence allows. So it's also the nature of the work that they're doing, which is compounded also by political circumstances and the executive, because the presence of an executive does have an influence on, at least I feel, does have an influence of how judges reason. And as does the media. So say, for example, just hypothetically, let's think of a scenario where the judges say that there is no evidence to give the Hindu side title, but the physical structure of the mosque was there from 1528 to 1992. Therefore, this belongs to the Muslim side and they can build a new temple. Just imagine what would happen if any of us were in that position. Would we have the courage to say that, no, we will not find in favor of the Hindu side? You are a Supreme Court judge. The legitimacy and the reputation of the institution is at stake. The media narrative has convinced you since the late 1980s that this indeed belongs to the Hindus. The executive seems to be all powerful, and you have now been tasked with decide. What will you decide? What is the safer route? The safer route is to legitimize so that your institution's legitimacy remains intact, so that you live to fight another day. Because if you do the other thing, then, plus remember, one of the judges went to the Rajya Sabha immediately after, which is Ranjan Gogoi. So there's also that. So I don't think you could have come to any other judgment than what they came to. It would have been an act of almost foolhardiness, institutionally speaking, to have done that.
Yeah. So there is a very interesting thing. They also did contradict themselves by asking to take a charges against the culprit who demolished the mosque.
Pramod, your voice is breaking.
My thing was, judicial executive, there is a certain law. Hello? I agree with the question which earlier came up as a, can we call it as a judicial, wording of it as a judicial history. There is a certain method is implicated in it. So I'm saying that method is a very random. It's not method as a method, rather it's a certain pressures of majority, certain other probabilities which are in functional. So that wording is bit I find difficult for me to, yeah, but it's a great talk. Thanks.
So on the method question, you are right. Probably it is, there is an element of randomness, because maybe one can fairly say that your judgments are conditioned by the circumstances in which you're issuing those judgments. Nevertheless, rhetorically speaking, because you still have to do reasoning in the judgment, you do draw on precedents. You do try to carve out a method. So one can, if one takes a number of cases, arrive at something akin to a method, which may not make sense to academics, but which is efficacious enough for the judiciary to move ahead with it. And given the real life consequences of what they can do, engaging with that method is also important. So, for example, I think one of the people who attended mentioned about other examples, if I could give. So if I could briefly talk about, there's this television show called The Sword of Tipu Sultan, which was a very popular television show which came out in the early 1990s. It was by Sanjay Khan. That television show was also taken to court, in the Bombay High Court first and then to the Supreme Court. What they did was, in the evidence that was cited, they cited gazetteers as evidence. So the Hindu side, I'm calling it the Hindu side, but it was the Vishwa Hindu Parishad and some others. They cited evidence which was basically gazetteers that were written 50 years after Tipu Sultan's death to claim that Tipu Sultan had committed basically crimes against humanity, although the term did not exist, against the people in what is now Coorg and people in Malabar. on the basis of which they said that therefore you should ban this series because the series is celebrating Tipu Sultan. The Bombay High Court does not do that. So then they go to the Supreme Court. The Supreme Court does not issue a judgment. What it does is that it says that based on these gazetteers alone, 50 years after, so that's just bad primary sources. 50 years after, they say that, okay, what we do is that we will not ban the series, but before the start of every episode of the series, there has to be a disclaimer saying that this is a work of fiction. And this is a work of fiction based on a novel called The Sword of Tipu Sultan. But if you read The Sword of Tipu Sultan, the original novel, which is Bhagwan Gidwani's novel, Gidwani in the preface says that this is a novel only because a novel is more accessible to the public. What I was actually going to write was a biography. And I had done research in 10 different countries and all sorts of sources I've collected to write a biography. Halfway through the biography, I stopped because I felt that a novel is a genre that can capture the essence of Tipu Sultan. So he is not engaged in fiction writing at all. He is doing a well-researched work of history where the genre is a novel so that he can fictionalize. Basically what Hilary Mantel did with Wolf Hall and Thomas Cromwell. That's the exercise Gidwani is engaged in. But by the use of 50 years after the events, gazetteers, the VHP and the Bombay High Court and the Supreme Court were managed to declare something fictional that was not actually fiction. And that's what's been happening with Tipu Sultan even today. This is the national pastime of Bangalore and Karnataka is to shit on Tipu Sultan, right? So that's also another example. And there are multiple other cases where this has happened. So there is some method to this madness.
I think Rishabh had a question.
Sir, yes, sir. Good evening, sir. I had a question, even though after hearing the discussion, I'm thinking whether I should ask or not. But then also, since I had it. Sir, only one single evidence was needed about that thing on this Ram Mandir issue. That one single evidence by the Jesuit priest, that was enough. But even though no other evidences from the Ramcharitmanas and Rama and answer the other sources which you told, they didn't have those evidences. Then how could the Supreme Court rely on this Jesuit priest's one evidence? And like, did he? Did they rely on it, or then after that they saw that the number of people coming from one period to another? And so one last question I had: the things which were found from that Ram Mandir, sir, were they examined, like that carbon dating done, that from which time period to which time period was it there? Because in 1520, if the Babri Masjid was created, and those things which were found, were they also examined by the ASI about their possible?
So the first question, yes, because as I was mentioning, what they did was they changed the standard. The standard is now what we are trying to look for is evidence of worship, not evidence of to whom the structure belongs, because from worship we will arrive at possession, and from possession we will arrive at title, and therefore the judgment. So now that if you're looking for evidence of worship, anything helps you tip the balance of probabilities on one side over the other. And that one travelogue, although they consistently cite two travelogues, but the second travelogue, which is Robert Montgomery Martin's, what they quote from the travelogue has nothing to do with worship at all. Nevertheless, what they're basically doing is that one travelogue tips the balance of probabilities in favor of the Hindu side, in favor of Ramlala Virajman. And that's all they need. Because the standard is not beyond reasonable doubt. The standard is balance of probabilities. And balance of probabilities says that this is more. You can very well legitimately make the argument. The very fact that there is absence of any reference of Babri Masjid in the Ramcharitmanas would suggest that the balance of probabilities tilts on the other side. But again, the context in which the judgment was made may have, we have no evidence to suggest that, may have led to a situation where the Supreme Court was just happy with this and they're like, okay, this is enough, we can now move on. And to your specific question about the Archaeological Survey of India's report, yes, they did do carbon dating, which is why they arrived at the claim that there is a 12th century structure beneath the temple. but there is nothing archaeological to demonstrate anything existent between the 12th century and the 16th century when the Babri Masjid was created. Which means that for 4 centuries, we are in an archaeological black hole. We don't know what happened. So therefore, how do you claim that the original temple was Ram's temple, or it was even a temple? There is also a huge controversy about that. If you're interested, there is an author named Ashish Avikuntak, who is an ethnographer of archaeology, and he's written this incredible book which talks about the controversy around how this report was created. And even the report's concluding chapter, which is the only chapter where the claim is made that there is a temple beneath the mosque, is an anonymous chapter. Every other chapter has an author. The last chapter does not have an author. And so there is a lot of politics of ASI that goes on into the making of the report, just as there's a lot of politics of the Supreme Court that goes on into the making of the judgment. Avikuntak's work is fascinating in that sense. But what he points out is this. And so the archaeological evidence is there, but there is actually not that much of an evidence of a temple existing. And even if you accept that a temple existed, there is no evidence to suggest that the temple existed beyond the 12th century. So 4 centuries of gap. So therefore, you need the travelogue.
Thank you, sir. Thank you so much, sir. Got it.
Thank you. Thanks.
I have a question, Srijan. So, I wanted to just, I think for us, we've sort of expanded what constitutes public history by telling us this is public history which is not emphasizing on communication as such, but rather juridical history is a form of public history in that it is legitimizing claims already existing in public discourse, and also the power that it has to reconstitute society and relations within it. So I think in that sense, it's given us new ways of thinking about what is public history, what is the scope or ambit of public history. So thank you very much for that. I think my question is similar to Pramod. Since I began teaching history, I've had this, like when you have to teach students what is history, we always sort of stumble upon it because the history that we are actually talking about is particularly 19th century formation of history in the West, where we're emphasizing sources. There is a certain degree of positivist tilt to it in a way, no matter how much we've moved away from it, whatever. But in any case, one of the things, because there has been so many contestations to history itself, or historical writing by historians, one of the things that we have concluded, at least for academic historians, is that history is distinguished by its method, by historical method, right? And that historical method is looking at sources, comparing sources, and interpreting past based on sources that can then be verified. In some sense, broadly, this is what we have concluded. And so we try to distinguish, I mean academic historians try to distinguish ourselves from, say, popular history or historical fiction by saying that we follow a method. Now, when we say juridical history, you are pointing to a particular method that is emerging in some sense in the judiciary. So that's a juridical method of engaging with the past. It's a nomenclature question, I suppose. So should we call this juridical history, or should we call this something like, juridical pasts that are being created? Because, we try to distinguish between past and history. Right? So it's a nomenclature question, but I feel like it's important for us to be able to clarify this in order to engage with this genre itself. So just some comments on that.
Yes, you are right in the sense that if we were to use the 19th century scientific history of the German variety as the barometer and how the discipline has evolved since then, at least based on my particular reading of this judgment, the judges don't meet that standard. And therefore, one can legitimately call what they have done as judicial interpretations of the past, or juridical or juridical past making, rather than history writing, which almost legitimizes what they have done within the discipline. But the reason why I'm calling it juridical history is that I am calling it juridical history within the context of public history. I wouldn't call juridical history a genre of academic history, because it isn't. It's not really doing it. It does not take seriously enough the conventions of academic practice in academic history, and it does not seem to have any commitment towards adhering to those practices. Because at each time, even in the judgment, what they keep doing, that no, that's not what we're doing. We are looking at the Indian Evidence Act. And because that's the standard of evidence we meet.
Right.
Now, one can legitimately, I suppose, say that the Indian Evidence Act would have a higher threshold of evidence than what we as historians use, but that doesn't seem to be the case here. So that's why I'm calling juridical history a genre of public history,
Right.
a history that has an impact on the public, a history that legitimizes the past in ways nothing else can for the public, and a history that can change the lives of the public. And for them, this is history. For the public, this is history,
Right.
far more than, say, what we may produce.
Sure.
And
Yeah.
which is, I think, what happens, because I remember Romila Thapar had written an article after the Allahabad High Court judgment had come out in 2010 for the Hindu. And many historians do write and comment on judgments that come out. And most of them tend to be dismissive, that this is not history, which it isn't in the academic sense. But for the public, it is the dominant, legitimate version of the past, sort of empowered by the judicial robe and the powers the judiciary has in trying to ensure that no one can criticize us also. So therefore, it's an interesting and a unique genre of public history,
Right.
and therefore worth engaging within the discipline of public history rather than academic history.
Right. Okay.
Do we have any more questions from the audience present? If not, we can end the conversation here. Thank you so much, Srijan, for joining us today and creating this interesting debate on thinking and reimagining history, public history, and the contested term now of judicial history. So thank you so much for joining us. And our next lineup of talks will be up on our social media soon. And please join us in the further conversations as well. Thank you so much, everybody.
Thank you.
Thank you very much, Srijan.
Not at all. Thanks. I hope I was able to sorry for the technology issues.
Yeah, the network was a bit off, but
Yeah.
other than that, I think it was fantastic, and because you were reiterating some of the points, it stuck with a lot of us. So it was really good. Thank you so much.
Thanks
Thank
a lot.
you so much.
All right. I see you.
Have fun with your new semester and new year.
Thank you, and same to you. See you.
Yes. Bye.
Bye.